Good morning and welcome to this webinar series which we're looking at heritage planning. My name is Andrew Shirley. I'm Chief Surveyor with the CLA. I've been with the CLA for about 25 years and both working across the Midlands and more latterly in London as Chief Surveyor, looking after the property and business team, which deals with best described as the sort of built heritage and economic functions within the CLA. Normally working out of our London office at Belgrave Square, but actually in Derbyshire at the moment, which I suppose reflects perhaps one of the triumphs of the CLA is that I have better broadband at home than we have in the centre of London. That's good. Just sort of a little quick talk about sort of heritage generally. We did a contribution of land ownership survey about 18 months ago now, and it showed that the majority of landowners have heritage of one sort or another. Not just listed buildings, but it could be any heritage at all. So it is a particularly important subject for us, and I think what we want to cover today is it's about the planning system and the heritage consenting system, how you can navigate your way through it. We're not going into the detail of what you might want to do in the end, but it's actually how you get there, how you get the consent, how you get the permissions going along. The CLA is always lobbying for change to reduce hiccups in the system, and the hiccups in the system are substantial, as we'll see. But those hurdles can be overcome, providing you're prepared and you put in careful planning at the outset. We will start today's webinar with Jonathan Thompson, who is CLA Senior Heritage Advisor. He will look at the sort of theory and the policy in a quick 10-minute presentation. Will then be followed by Paul Crosby from Crosby Granger Architects, who will give an architectural type of view, and then we will hear from James Whilding, who is a solicitor, who is a charter surveyor with Acorus. So you'll get different viewpoints from the three professionals talking to us. Then after we've heard from them, we'll go into a panel discussion based on the questions you ask. If you've got questions you want to ask, can you please do so using the Q&A button on the bottom of your screen. You can ask questions anytime during the presentations, but we'll answer them at the end in the panel session, and that will make sure you have the opportunity of hearing from all the speakers today. You don't need to take notes. This will be recorded and will be sent to you as a web link afterwards, and also will be available on the CLA website if you want to review the content later. Just to remind you also that the CLA does have a good suite of guidance notes, particularly on heritage, which can be found by CLA members on our website. You will notice that this event focuses on England, and that's because there was a similar presentation that dealt with Welsh issues in March. However, if there's anyone here from Wales, the principles are very much the same, so but please hang in there. You'll see on the screen the Q&A button sort of displayed on the slide there. That's the one you press to leave comments. Okay, so we'll progress on now to Jonathan Thompson. Jonathan Thompson is Senior Heritage Advisor for the CLA. He's worked in heritage for years. He's a charter surveyor. He sits on the Historic Environment Forum and the Heritage Alliance Rural Group. And before he worked for the CLA, he was a director at the Landmark Trust and also chief executive of the Architectural Heritage Fund. So he's worked in heritage for a long period of time. And I hand over to speak to him. Jonathan.
Thank you very much, Andrew. The heritage protection system is, of course, big and complicated, and I certainly can't cover every detail in 10 minutes, and I'm not going to try. So this is going to be a gallop, brief outline of the system, of the problems and of how you can overcome them. It's designed primarily for owners of heritage. As Andrew said, nearly all CLA members are heritage owners, between 90 and 99%, according to the survey that you mentioned. Owners are in a very different position to other heritage audiences. Of course, anyone can have perfectly legitimate views on heritage, but owners actually have to manage it and look after it and pay its costs. Moving on. Most owners, despite what I've just said, strongly support heritage protection in principle, or maybe more accurate to say that they would if they felt it was effective and proportionate. There's, of course, a degree of annoyance that people are telling you what to do, but usually they're not contributing to the bill. But of course, a wider interest in heritage is not all bad. The public, the users, tenants and customers, and so on. Moving on. The system basically comes in two stages. One is the sort of what is heritage stage, and the other is the consent stage. In terms of what is heritage, well, obviously there are listed buildings, scheduled monuments, parks and gardens, battlefields, World Heritage Sites and conservation areas. I won't get into the detail of that. I will just briefly mention two other things which are not so obvious. The idea of non-designated heritage assets, including things like local heritage listing, may not be so obvious. If a building isn't listed, that doesn't mean it's not heritage or it has no significance. It can be material in planning decisions, so you do need to think about it. And the other related point is setting. Most heritage, nearly all heritage, has a setting around it. The effects of development on that are, again, material in planning decisions, so it's important not to forget that. Moving on. Then there is the consent stage. The specific heritage consents, listed building consent, scheduled monument consent, and of course there is also planning permission, which becomes very often more difficult and more expensive where heritage is involved. And of course there are the other consents I'm not going to talk about today, building regulations, back licenses, and so on. Do these controls work? Well, this system was really set up in the 1970s in a sort of sudden lurch from a situation where, frankly, you could bulldoze anything you liked and no one bothered that much, to a system of disproportionate control, a sort of pendulum swung, and you kind of needed listed building consent every time you wanted to draw breath. Did this system work? In other words, did it encourage good change and discourage bad change? Well, I think the 1970s system didn't. Things have moved on, as I'll be saying, in theory, a bit less so perhaps in practice. But I want to look at the 1970s system next, moving on. That basically had kind of 10 rules, some written, some unwritten. Rule 1 was that heritage must be preserved, the P word, i.e. essentially unchanged, the so-called presumption in favour of preservation. Rule 2 was that what was called historic fabric, i.e. the actual sort of bricks and mortar, especially must not be changed. Rule 3 was that any component, even if wholly inappropriate, the sort of 1950s carved fireplace in a beautiful Georgian room, had to be kept because it was part of the history of the building. Rule 4, moving on, was that buildings needed to stay in their original use, which was the only valid use. Rule 5 was that the decisions needed to be taken by heritage experts in the local authority. Rule 6, of course, was that the needs and views of owners were irrelevant. Rule 7, moving on, is that the needs of the building, including viability, are also irrelevant. Rule 8 was that the only function of the owner is to pay the costs of whatever the local authority decides. Rule 9 was that any certainty or guidance are bad because they fetter the discretion of the expert on the day. And moving on, Rule 10 is that any transgressions carry draconian punishments, at least in theory, huge fines and imprisonment. Now, you might be thinking that this perhaps wasn't a brilliant system, and I wouldn't disagree with you. You might also be wondering why it didn't cause complete disaster, and the answer was that there was a sort of safety valve in that the local authority experts could, and sometimes did, choose to waive some of the rules, if they choose, but you didn't really know whether that was going to happen or not in advance. That is, as I said, not a great system. Moving on to the next slide, please. Can we have the next slide, please? Can I have the next slide, please? Yes, thank you. That approach, although I said it was not great, was loved, and that's not too strong a word, by many heritage people. And it was questioned, certainly questioned by owners, but it wasn't really questioned by heritage people in this country. It was questioned internationally, particularly on the other side of the world, in Australia, where people thought maybe this preservation thing wasn't that clever. And they kind of invented conservation instead, and that was spelled out in the Borough Charter as long ago as 1979. There was lots of CLA and other lobbying for years and years. Historic England eventually, through gritted teeth, produced a policy they called Constructive Conservation, although they've tended to do their best to ignore it ever since. Finally, the key step was new national planning policy for heritage and everything else in the National Planning Policy Framework, the NPPF, in 2012, and new guidance, importantly, the planning practice guidance, the PPG, in 2014, and also under those, new and better advice. Moving on. So this new approach is, in principle, completely different. Heritage is not preserved, it is conserved. And conservation, that doesn't mean keeping things unchanged. It's defined as, quote, the process of managing change. And thirdly, conservation is not of everything. It is of significance, i.e. what actually matters about the building. So if something isn't significant, then potentially it can be changed. Rule 4, moving on, is that heritage needs a use. It is recognised that it needs a viable use if it is to survive. And if that means a change of use, so be it. Fifthly, proportionality for the first time ever in decision-making and in information with applications. And sixth, this approach sees guidance and advice as okay, indeed good, and much that is then actually published. So moving on, has the problem been solved? Well, it's only much better on paper. There are two main problems. The first is that local authorities often try to ignore it in practice. If you let them, they will revert to the traditional system. The second one, importantly, is lack of resource. This is a big state system. It assumes that local authorities have big teams of skilled conservation officers. They don't. These teams, if they ever existed, have been cut and cut. So, and it causes all kinds of problems in practice. The CLA and others are promoting further reform, but that's very, very slow. Next slide. An example of that, a big piece of progress in the last month, is that for the first time ever, in 52 years of the listed building consent system, for the first time ever, we now have advice on listed building consent, and whether you need it or not. That's terrific, but it has taken 52 years. So don't hold your breath. Don't wait for me to reform things. Next slide. In practice, the key point really is that success is largely up to you. Get it right, and you probably get your consent. Get it wrong, and you probably don't. So next slide. And here are my 12 rules for success. The first is allow lots of time, and also don't forget that. Secondly, consider, of course, the non-heritage planning issues, traffic, new development in open countryside, hated by most local authorities, and so on, and deal with those. The third one, heritage specific, is take heritage seriously and don't leave it to the local authority. Take control of the heritage aspects yourself. If you leave it to them, if you invite them to walk all over you, they probably will. And treat the local authority in a professional way. And don't treat them with high-handed arrogance, of course, but equally don't go to them on your knees saying, please, sir, will you let me do this? They're supposed to be professionals acting in a professional way, so approach them in that way. Rule 4, next slide, please, is, and the key one really, is before you do anything, do not go ahead and design anything. Before you do anything, investigate the building, analyse the building, understand the building and its heritage significance, know it well, know its structure and defects, use the CLA guidance notes, which have quite a lot about this. Then rule 5 is consider what heritage issues arise, and also, of course, what consents you need. Lots of guidance notes on that, including whether the building is or could be covered by listing, especially thinking about the possibility of attached and curtilage structures. I'm not going to deal with those now because I'm sure there'll be questions about them later. Rule 6, next slide, please, is consider, even if you're not thinking about this, nevertheless consider the long-term practicality and the viability of the building. Then rule 7 is work out your objectives, particularly how can you ensure practicality practicality and viability in the long term. Rule 8, if you need change, is to devise proposals which reflect and respect the building's significance, which you've already looked at. Rule 9, next slide please, is that you need a heritage analysis, and I'm using the word analysis deliberately. The word statement doesn't really capture it. Explain, having analysed the building's significance, explain that you have respected its significance and also how you have respected its significance in writing. Also, Rule 10 in your application, it's vital to quote the NPPF and the PPG and the advice. You need to remind the local authority that the new system exists and that it needs to follow it. Rule 11 is that you can do all this yourself as an owner using the CLA guidance notes, but if you don't want to do it yourself, particularly if the issues are complicated, then use a carefully selected professional like Paul or James, and that's also covered in the guidance notes. And finally, Rule 12, next slide please, which is that if you have followed all these rules, you should succeed despite the problems. But if you still run into problems, it's probably the fault of the local authority, so persevere. You may well still get consent or win at appeal. So it leaves 2 final points. Firstly, good luck. Secondly, next slide, please. A quick PS on guidance notes. I've mentioned guidance notes and so has Andrew. They look something like this. Next slide, please. Here's a list of some of the CLA guidance notes on heritage. I won't go through them all. Yeah, it gives you some idea of what is provided. So thank you very much for listening.
Thank you very much, Jonathan. A really good start to the subject, and plenty of things for everyone to think about. Please, all of you, remember to post any questions in the Q&A. There's a question there already. Are the slides available after the event? There will be a complete presentation. The link will be sent to you, so you will have the slides that you can look at after the event. Now, can I introduce Paul Crosby? Paul set up Crosby Granger Architects in 2014. It's a practice that works on a mixture of private and public projects based in the Lake District and Yorkshire Dales National Parks. An interesting mix of work. He says he believes in the sympathetic and appropriate use of materials and techniques for conservation. So there's quite a lot there. He's also a technical advisor for the Society of the Protection of Ancient Buildings as well. So he has a lot of experience, and here he is, Paul.
Hello, good morning, everybody. It's very nice to be here and invited. And I'm hoping that I can add something to this from a practical architectural point of view. If you can move on. The basis for this is about planning background, which I think Jonathan has gone through quite well in his rules, which is brilliant, and what kind of consents we need for repair and conversion. Now, conversion does tend to add an extra series of hoops or complications which can bog down an application. But as Jonathan said, what we need to do is look into and identify the significance and determine, to help us determine informed decisions. It's all about informing any application, whether it's a listed building, whether it's a non-designated heritage asset, which is something which is locally listed, or simply something either in the curtilage of a listed building or just deemed by the local authority or the national park that you're in to be of significance, something that they feel looks and affects the character and setting of the landscape. If we can, so what I'm hopefully going to do is add to Jonathan's description and from a practical point of view, advise on how best to overcome these. So moving on. I'm slightly repeating a little bit of Jonathan's discussion, but drilling into the national planning policy framework. This is something which you can use to your advantage. It's something that is set out it's a government document and it's easily findable if you Google for it. But the important elements of it, just drilling into it for you, are achieving sustainable development. This is where you can argue over the viability of a scheme and prepare a strong response to the elements in the paragraphs noted that can strengthen an application. Chapter 6 is to do also with viability, whether it's a building that is no longer viable in its original use, a barn, for instance, and you need to look at ways that can ensure its survival. And so be arguing that, plus, as chapter 16 goes on, these are areas where that is a case of conserving, as Jonathan said, not preserving. We have to be arguing that listed buildings certainly need to be kept in a viable use. Without a use, we lose maintenance, we lose a sense of it being part of a set of important buildings, and the inevitable happens. So, and I think with a decent argument that you take control of the discussion with your local authority or national park and put to them an informed decision which argues, basically using these chapters and the paragraphs within them to bolster your argument. So moving on. These are, I won't go through these because I think this is something you can pick up on the slides when you get them, but also Jonathan really went through it. It's about how we can be specific about the listed buildings, if they are listed, and the contribution they're making, and consider that in the way that our proposals might affect the building. So considering potential impacts, whether that's new windows or simply just a change of use. It might be that you can reuse a space and adapt it in a way that almost is imperceptible. The other end of the scale, it could be that you really need to do a quite high impact, but that's not to say you would not get permission for this. It just needs preparation of a discussion to explain the process that you've gone through to come to what you'd like to think was an inevitable option, which is the minimal impact, whether listed or a non-designated heritage asset. They talk in terms of harm, which sounds like you're going to get go at them with a sledgehammer, but it's more to do with harm to their significance and to the fabric, the bricks and mortar of the building. So moving on to the next slide. Historic England also have a big input on this, and as Jonathan said, they've now started with some useful advice on listed building consent, which is great because that gives a lot of clarity and helps you as an owner to do the groundwork, to start to understand the parameters which you are working within. And so the adaptive reuse of traditional farm buildings is a really useful document to help you, and if you're guided by a conservation accredited architect, surveyor, engineer, they can also help you to present hopefully an indisputable argument as to why a building needs to be repaired, and that repair includes potentially conversion to allow it to be a viable and encourage its sustainable long-term use. So moving on again. Similar documents. I won't go heavy-handed into this, but the character assessments are also a useful way to see how your locality is perceived. So there's a summary for the whole of the country, and then it drills down into regions. These are useful because it picks up what are significant elements, or what is perceived as significant elements, generically across a region, northwest, southeast, etc. And that helps to formulate this argument that you would need. Moving on. So local authorities have their own local plans, which will guide design, historic environment, alteration to it, what they consider distinctive areas. So these are almost going more in detail than the distinctive character of the local authority. And housing, potentially, you can use this to encourage or to make viable change of use to agricultural buildings if it's seen to be either supporting the farm holding itself, if it's for managers, etc., or simply as a sustainable reuse of redundant buildings. We've had a number of cases where we've done that with large barns that's without use, large but unusable in modern agriculture, would not have a use. So the idea of breaking those up, and depending on the ebb and flow of the local plan, sometimes we get encouragement for holiday lets or for smaller apartments that can have local occupancy. So that's something which is a big subject in itself, but local occupancy is a way of sometimes being allowed development, but limited to your local area. And the neighbourhood plans are items which deal with these as well. The interesting thing about neighbourhood plans is that you, as or your town council, local parish, can influence the way that buildings are perceived and uses of areas are perceived. So where development can and can't happen can be considered within the neighbourhood plans. Moving on. So just a couple of practical applications of things we have done within a local authority where they're listed buildings. Actually, this one isn't a listed building, but was classed as a non-designated heritage asset, effectively like a local listing. This is in Kentmere in Cumbria, where it was a farmhouse with a adjacent barn, no longer used and falling into disrepair. And so we had the age-old argument of trying to encourage a use. In this instance, it became an extension of the house, so that the house fell through into the barn. So change of use for that, but also listed building consent and planning permission for the change of use. Interestingly, just as a small aside, here we put on elements at the back of the house. So this building looked a little bit less glamorous than this. So moving on is a kind of before shot. We move on. So that's what it looked like before. So the roof was caving in, and this is the rear of the building, which had a fairly grim 1970s extension, which was just simply needed because they needed the space, but wasn't very sympathetic to the building. So moving on. We discussed and a little bit of horse trading with the local authority, and this is where it's good to have your significance and an informed, what they call a value-led set of criteria and arguments towards a building. So here we simply took down the extension at the back and put on a very modern thing. So don't dismiss things which are contemporary. Often they're not appropriate, but here on the rear of the building, we actually were allowed to do planning permission for this. It's not on the principal elevation, so they weren't quite as tetchy as normal. And we've got fantastic views of Kentmere from the dining room. So moving on. So the art of possible is open to discussion. And as Jonathan was saying, it's for you to be able to argue those points. So internally, we put a lot of glazing into the openings we had to maximize lighting and quite a contemporary internal use. Here we, as Andrew was saying at the beginning, I believe passionately in traditional materials as well as a new design. So the walls have got insulating lime plaster on them, so it improves thermal performance, but still is inherently sympathetic to the fabric and can create great spaces within otherwise unused environments. This is a building which is attached, but we've done similar elements where we've had buildings that are either within the curtilage or standalone. I think an important factor to consider is impact and how close your potential development is to infrastructure, roads, and services. This will have a factor in how well your arguments can go towards its impact on the character and setting of the environment. Moving on. So another advantage, example here is, well, that's the before shot of a building which was absolutely struggling to survive. It had been stripped of a cement render and was listed, this is grade 2 star, but was performing exceptionally badly. So with some research and investigation into, well, the significance of this 15th century house, it doesn't need to be an old house and it doesn't need to be listed. It's all about finding out the significance and getting your argument robust. So here we needed to protect this building. It's in a very, very exposed position and it needed to be looked after. So we, against or a reluctant local authority, argued the toss for putting a render back on to allow it to perform as it should have done, because this historically was the way that the building would have been protected. But we also managed to slip in a small extension, which is in the middle of that elevation, to allow the building to have a storm porch, which it didn't previously have, which in this case is very, I'm hoping, very sympathetic and actually just feels like it's part of the original structure. And that was part of the argument to the local authority here. So very sympathetic, but allowing change to conserve, protect, and enhance this building. So moving on. That was it before, moving on again. So this is an element of the before and after. We're hoping to roll around this, and that's a detail of a window that was struggling, a finished product of hopefully something which looks quite lovely. And then following on from that, this is, these are your settings. Sometimes, I mean, this is the Lake District. This is what they're concerned with, is affecting the character and setting. If you can argue about the significance and its place in the environment, you're already on a good, strong footing towards a successful application and a successful listed building consent change of use. So that wraps it up for me.
Thank you very much, Paul. Very useful illustrations, particularly as to how you can tackle the character of buildings which are so important to the landscape. If we now move on to James Whilding, he is a managing director of Acorus, which is a nationwide firm of chartered surveyors. He is himself a chartered surveyor. He's also chairman of our Devon County Committee, the CLA. He's had over 25 years experience and specialises in all aspects of rural consultancy. So if I hand you over to James.
Thank you very much, Andrew. Good morning, everybody, or it probably is getting, yes, it still is morning. So I'll briefly just touch on a couple of test cases that we've been involved in, just to add weight to some of the comments that are made by previous speakers. First one was the conversion and a replacement of agricultural buildings to create 5 residential units in East Anglia. Now this scheme, and the key barn is in front of you there. The idea of the redevelopment and initial discussions have been going on since 2002, so it's not been a quick process at all. But after much consultation with stakeholders, an agreed proposal was finally put to the table for approval. Now, this is a typical modern day situation where buildings are redundant to any suitable future agricultural use, and without intervention and a sustainable use would deteriorate beyond the point of conversion, thus affecting their setting within the countryside and lead to the potential loss of these important heritage assets. We reviewed the alternative uses, and it was accepted that employment generating schemes were unsuitable because of the distance from major economic centres, the scale of the buildings involved on the site, and also the general lack of demand in the locality. As I say, the proposal for the 5 dwellings included the conversion of this grade 2 star listed barn with glazed link extension to form a single dwelling. The principal delay in any planning application was due to the potential conversion of this barn which was debated by stakeholders at great length. The main barn, as I say, is grade 2 star listed, and its status relates to its quality and its date assumed as early as the 17th century. Now, the provision of a supplementary heritage statement raised considerable doubt as to whether it was in fact 18th century in considering historic mapping. And this was significant as the special characteristics of the grade 2 star site can raise the expectations with regard to acceptable levels of change in accordance with the NPPF. And this goes back to what Jonathan had said about understanding a lot about the listed building from the outset, and not always trusting what's in front of you. Where a development proposal will lead to less than substantial harm to the significance of a designated asset, this harm should be weighed against the public benefits of the proposal, including, where appropriate, as mentioned, securing its optimal viable use. So working proactively, and this is one of the important things here, with the case officer and the colleagues, in addition to Historic England, it was accepted that the removal of large 20th century modern buildings would be of great benefit to the setting of the listed barn and the group generally. However, the domestication and addition of modern extensions potentially diluted the improvement, though the use of modern forms helped the viewer to read the stratified history of the site. Overall, it was accepted that all the barns had no material impact on external amenity, and the proposal was eventually supported. But it was a fine balancing act to get the degree of conversion, the modern extensions, the provision of modern extensions, and protecting the historic importance of particularly the listed building, and getting all of that right to everybody's agreement. Moving on to the second example, and I raise this as a Class Q, and a Class Q, for those of you that don't know about Class Qs, and there can't be many now, but is the change of a use of a building and any land within its curtilage from an agricultural building to, or an agricultural use to a C3 use class dwelling house. Now, this is one of the permitted development rights that the government introduced back in 2014. And with regard to heritage and landscape designation, these rights do not apply, at least in terms of Class Q, do not apply to listed buildings or sites which are or contain a scheduled monument, but also where buildings are within national parks, AONBs, conservation areas, World Heritage Sites, and SSSIs. For Class Qs, a prior approval procedure is in place whereby the developer must submit a prior approval application to the LPA for them to consider. And it must be noted that the principle in converting the barn to a dwelling has already been accepted by government. So the LPA themselves must only look at the location or the siting of the building as to whether it's impractical or undesirable for its change of use to take place, highways implications, noise, contamination, flood risks, and overall design. So in this particular case, the building, you probably see in the background, there are some more traditional buildings. The building qualifies in that it is or has been in a solely agricultural use, and it's not a listed building. And whilst it is within the setting of the adjacent grade 2 listed building, it does not form part of the listed group and is not within the curtilage of the listed building, hence why it qualified for permitted development. Despite this, the council opinion was that the proposed development would result in harm to the setting of the adjacent listed buildings, and therefore they used the impractical or undesirable prior approval consideration as a reason to object. In terms of undesirability, the challenge was to seek agreement that the issue related to why the building cannot be residential in its use, and not a question of whether the existence of the building was unacceptable. The argument here was that the reuse would preserve the setting, if not enhance it. In referring to Historic England advice and guidance, conserving or enhancing heritage assets by taking their settings into account need not prevent change, and this has been highlighted previously. Indeed, change can be deemed to be positive, noting particularly where the setting has been compromised by poor development. To assist the LPA in this particular case, we undertook a Heritage England assessment based on their 5-step principles to firstly identify the heritage asset and the settings that would potentially be affected. We assessed the degree to which the settings made any contribution, the effects of the proposed development, whether beneficial or harmful. We explored ways to maximise enhancement and avoid or minimise harm, and also document a decision and monitor any outcomes. And in seeking to provide enhancement through the reuse of an existing building for an economic purpose, retaining the rural character and the bulk in the landscape setting. And because of all of this, it was accepted that the overall harm was just the change, and that the change had already been accepted in principle. It is typically difficult through permitted development right processes to engage with officers. However, as with any form of application, proactive consultation in many cases results in a positive outcome. The previous speakers have touched on a number of issues that are still outstanding in the system, some of which have been outstanding for a long time, some of which are very much more COVID related. But there is an issue with resourcing within the LPAs, and particularly the heritage departments, and it is unlikely that government are going to find a large pot of money to substantially invest in these departments, and therefore really the local authorities have got to prioritise on the most important buildings and advise accordingly. As emphasised in the NPPF, and noting that the latest version came out yesterday, is that officers do need to be positive, proactive and solution finding. And this is particularly relevant to heritage planning, where we need everybody on board. The other final point I would make is about cost, and the idea of proportionality, and in some cases the choice of materials. As noted in one of Jonathan's briefings, the demand for unnecessarily expensive or no longer appropriate materials, I think, does very much spring to mind. Noting the importance of Q&A, I shall stop there, but happy to answer anything for the next 20 minutes or so. Thanks very much.
Thank you very much, James. Very helpful. We have got about 20 minutes left for questions and answers, so I would like to move on to that fairly swiftly. I'll start with Annabelle Hutchins. One of the first questions we received, which caused me made me smile. It is about how should curtilage be defined, which happens to be one of Jonathan Thompson's particular areas of interest. So, Jonathan, shall we start with you on that?
Yes, difficult to cover one quickly. This is a big problem, which is a kind of hangover from the traditional system I was talking about, the sort of idea of curtilage listing, particularly the myth that listing a farmhouse, quotes, automatically lists all the farm buildings, which it doesn't. This is at least a quarter of the CLA member inquiries that I get, members who are worried that their local authority is claiming that one of their buildings is listed, despite not being mentioned in any list description, and that leads on to all kinds of problems. The local authority saying that listed building consent is needed and they wouldn't grant it. Permitted development rights, they claim, disappear, like Class Q, which James is talking about. And possibly the worst case is that they're saying that work you've already done was illegal, accompanied by threats of prosecution and enforcement. Don't panic. The first step really is to look at the law and the facts. The law and the case law actually are quite clear on this, quite straightforward. What's covered by listing is firstly the listed building itself, as secondly, any attached buildings, provided they were in the same ownership and also ancillary at the date of listing. And I'll just say very briefly what ancillary means. Essentially, it means it's in a subsidiary use to the use of the listed building. So where a house is listed, a granny flat or a gardener's cottage or domestic storage probably all are ancillary. A dwelling let to a third party or a barn in agricultural use are not ancillary. So listing covers the listed building itself, it covers attached ancillary structures, and thirdly, which is what this question is driving at, it covers unattached structures, but only if they are pre-1948, and also at the date of listing, they were in the same ownership as the listed building and were ancillary to it, and also in its curtilage. So there is such a thing as curtilage listing. It certainly does cover some buildings, and you need to be aware of it, but it only happens where all those criteria are met. Very often they aren't. In general, I would focus on the word ancillary rather than the word curtilage. From a CLA member viewpoint, the key point really is that barns in agricultural use are not ancillary to a listed building, and therefore not covered by its listing. That doesn't stop the local authority claiming that they are until the cows come home. In fact, literally until the cows come home in these cases, very often. What do you do about this? Well, there's a guidance note about it called What Listing Includes. Don't look at the Historic England advice, which is seriously misleading. Use the CLA guidance note, work out the answer. Probably not that difficult. Main thing is to get in first. Don't let the local authority think about this first. Get in yourself, get the answer to the local authority before it has its own answer. That usually works. If you can't do that, it gets much more complicated, but there are some solutions in the guidance note. I hope that answers the question.
All right, thank you. Another couple of questions actually for Paul, I think. One was, did you install EWI to the render? And another one saying, was the line, what was put in the lime plaster to help it insulate?
Right, okay, quite technical questions. So the internal insulating lime plaster had hemp in it. So it's a lime-based mortar. It's about 80 mil thick, but it can vary. One of the things is because it's got a hydraulic lime content to it, which gives it a stiffer mix, allows it to be put on in fairly thick layers. So there's a couple of courses of that. We actually did it and left it without plaster on the outside. So it's still, you could see the hemp, which is actually quite a nice grain to it. But you can, of course, make it smooth, make it just look like a normal plaster. So that was the internal plaster. The external render was a lime render. Now that didn't, we did that a few years ago, and at that point we weren't using glape or any of that type of element to insulate externally in the render, but I think we would consider it now. So that was actually a hot line mixed render that we put onto to the large kind of ochre coloured building. So no external insulation on that one, although the walls were about 9 foot thick, which has got to help.
Thank you very much. I was wondering if we could have thoughts from the panel on how we deal with repairs to listed buildings. There's quite a lot of difference between different local authorities about repairs required to listed buildings and what is a repair and what is an alteration, and therefore which requires consent and which doesn't. Paul, do you want to?
Yes, it's a question I get asked a lot as a practitioner, but also through the SBAB technical helpline as well, as to what constitutes a repair. And I think a little bit, as Jonathan was saying, you need to take the bull by the horns in this situation. A lot of repairs, as long as they're like for like, can be done without listed building consent. But I would caveat that with, it's always good to have a good working relationship with your local authority, the conservation officer, if it has one, and to make sure that you're not going to disfavor yourself for other developments. Often the repairs that we get involved with are part of a wider scheme, so we will include them anyway, just to enforce the idea that we know what we're doing. And this is all about the viability of this building. But a lot of repairs can be done without listed building consent. So it's not a foregone conclusion that that is the case, but I would caveat that with a conversation is always useful.
Yeah,
can I just add in there that there is the new Historic England advice note on this, which I mentioned, the thing I said we've been waiting 50 years for, which does go into quite a lot of detail, and there are pages of tables at the back, which cover a lot of works that you might want to do. In general, the formula is that this work does not need listed building consent unless, and there are then usually sensible exceptions to that. So I think that is a big step forward. It's not perfect. One of the questions which touches on this asks about thatch. And I think, unfortunately, this new guidance says if you're rethatching an entire roof, you do need listed building consent. I'm probably trying to get that out, but unfortunately, it's still in there. But in general, the guidance is good and helpful.
Great, thank you very much. There's quite a lengthy question from Christopher Woodward from Shropshire, and I think his concern is that whilst the maintenance of the building has to be paid for by something, quite often by diversification, there is a missing link, I think it's probably the best way to describe it, between sort of trying to get listed building consent for the maintenance of buildings against actually being able to, or not able to get planning consent because, for example, you have to arrive at a site by car, and therefore that impacts in a different way. So I wondered if James might want to answer that. It is something that we are acutely aware of in the CLA, and we're doing quite a lot of work to try and get sustainability to be actually looked at in a modern way rather than a historic way. But I thought I would give James the opportunity to answer that. And if you could also pick up the question that was asked about the changes to the National Planning Policy Framework that was announced yesterday, would be helpful. Thank you.
Okay, thanks, Andrew. Yeah, in terms of sustainability, I think you know, councils have, whilst we all know that sustainability is this three-pronged force based on social, economic, and environmental impacts, is that planners do tend to focus very heavily on highways and transport. And the availability of a you know, bus stop at the end of your driveway. I think, you know, you do have to look at the NPPF, and there is acceptance there that, you know, or some acceptance that in rural areas, clearly, you know, there aren't the transport links that you might get in the centre of London, for example. So there has to be a degree of flexibility here. Now, that's not always easy to overcome. And I think it's just trying to find compromise with planners, with county highways, to argue the sustainability, because also you've got to look at the wider sustainability benefits. Whilst you may be outside, and many of our members live in these rural areas where, you know, they're outside of settlement boundaries, there is this benefit you can provide to the local settlement even though you are outside of it. So that needs to be borne in mind as well. And obviously, you know, things like COVID as well, we've just got to bear in mind is that planning policy doesn't reflect that because it's all out of date. And, you know, what is people's mentality going to be moving forward? You know, we know that public transport in rural areas is very poor anyway, and it's unlikely that the government is going to be investing in that in any significant way. Take out the significant at all, probably. So it will be interesting to see how everybody considers this moving forward. In terms of the NPPF, and I had a quick look at it last night, I have to say there's not a massive amount of change in terms of the heritage chapter that I can see. And in fact, in terms of a lot of our rural planning, I would say there's not a dramatic amount of change there, but it is there and available for everybody to see.
That's very helpful. Another question we had in, and I can't just find it on my screen at the moment, was around solar panels and those who wish to put solar panels on listed buildings. I know, for instance, there was an application not very far from me in Derbyshire, which were putting solar panels on the back of a listed tea rooms, which was turned down by the national park and then was successful on appeal. But I just wondered if there's any more clarity on solar panels where they don't impact, obviously, the view of the building itself or the character of the building itself. Any, Jonathan, would you want to comment on that?
I certainly can comment on that. I mean, in general, you have to follow the normal rules. And if you want to put solar panels on your building, then you will need to justify any harm involved in that. So you need to think about the building, think about minimizing the harm. If there is any harm, you need to justify it in terms of the NPPF, and the NPPF has chapters on climate change and stuff which you can use. Whether that will work is slightly hard to predict in many cases, but in some cases it will, in some cases it won't. So you can try talking to the local authority if you can get any answer from them as to what their attitude to that would be.
Thank you very much. Also, another question from Emma Diamond. Is there any particular differences if your buildings are in areas of outstanding natural beauty, or indeed actually a national park, for example? So will they be? Would there be greater scrutiny? Shall we go to Paul, as he works in 2 national parks?
Yes, there is great. Hello. There is great scrutiny. I'll just say on the solar panels, there are cases here in the Lake District National Park where they have accepted solar panels and not having to go to appeal, but in an offset area, so away from the listed building, that has been masked, so it didn't affect the key buzzwords of character and setting of the listed building. So in those instances, we have been able to do solar and also biomass, lots of sustainable solutions that can be used, but it's just about the impact and you arguing how you're going to manage that impact. So I think, as Jonathan was saying, not a yes or no, but it is possible depending on your argument. Yes, within the national parks and World Heritage sites, scrutiny is more focused. So you need to be more prepared and more robust potentially in your arguments. It becomes a little bit more complex when it's in a national park, and even more so when it's in a World Heritage site. So these areas really do need you to look at the NPPF, but also the documents which run alongside the national parks, and for you to drill down into those. As Jonathan was saying, it doesn't preclude anything as long as you are very clear in what you're doing, why you're doing it, and the impact you're doing. So heritage analysis, as Jonathan had said earlier, is very, very key. It's not just a statement, it's an analysis of what you've got. But then also, we tend to now prepare a heritage impact assessment as part of that, which we try and tabulate. So it's not subjective, it's not esoteric, it's just very much about the facts of what you're doing. And national parks seem to respond well to this laying down of what you're wanting to do, how you're going to do it, the significance of the elements you're approaching and their setting, and the impact or mitigating circumstances. Because as we keep on saying, things are possible. You just need to have a good argument and explain mitigating circumstances. So yes, it's tougher, but I think you just need a better argument.
Thank you very much. There are a couple of questions we've had on local designated heritage assets, or even undesignated heritage assets. How do you find out where they are? Without obviously drawing your local authority's attention to the fact that you might have something that might be of interest. Jonathan.
I mean, only about half of local authorities have these lists at the moment, and they're very often out of date. There may be an expansion of them because the government is, Robert Jenrick, the community secretary, is trying to encourage them. There is a project to expand them across large chunks of England, so they may become more common in future. There is supposed to be consultation. I think usually is, but there hasn't been much of this going on in recent years. But certainly the guidance from Historic England says that people should consult. So I hope that that's going to happen. And these do have some importance because they do then become material in planning decisions. And as Paul was saying, you're going to have to make the arguments that much more strongly in those cases.
Thank you. Another question about openings. Quite often openings are resisted in heritage buildings generally. I wondered if James had anything particularly that he wanted to add to that.
I think it's interesting. It's not just, well, I suppose, heritage. You know, any traditional building. You always need to try and minimise the amount of new openings. And again, it's just coming down to a justified reason as to why you need it, and so long as it's not excessive, so long as you're still trying to protect the integrity of the building, you know, the character of it, then hopefully, you know, you will find agreement with the local authority and with conservation or list building officers.
Thank you very much, James. One final question is all we've got time for, which is about extension to buildings and whether these should be similar to the listed building or something modern. And can I let Paul answer that briefly?
I'll be as brief as I can, but it is a perennial issue, and it's one that can, if it's let get out of hand, be quite a subjective thing with local authorities. You can get into all sorts of problems with this, which is, I think, why that analysis and argument on significance is absolutely key, because you can argue either way. It depends on settlement for, you know, surrounding buildings. Can they withstand, say, a contemporary building? Because a contemporary, certainly from an SBAB point of view, but also from just a general principle point of view, a modern building can achieve good levels of insulation, be honest to its age, but still be sympathetic to the historic building. I think that's the key thing. It has to be sympathetic, and that's visually, but also technically as well. So it's not going to be a detriment to the historic building in any way. And I think then you've got a really solid base to go and say, I suppose in the preservation conservation, this is about arguing about a development, an evolution that you need to put forward as your case, rather than just preserving an aspect. So some instances do require a much more steady, conservative hand, but I wouldn't say every case needs to look like the building it's on. In fact, the opposite. I would say it's quite nice and refreshing when done well and to a design quality. And I suppose one of the updates of the NPPF is that they're wanting greater quality in design. That's what they're trying to encourage. So that could be contemporary design as an extension.
That's great. Thank you very much to all the speakers. I hope it's been an interesting response. It's good to have a policy angle, an architect's angle, and a surveyor's and planner's angle to all of these questions. We will take away the questions we haven't had the opportunity to deal with because they're helpful in us finding a policy way forward. Just want to thank you all for attending this event as well, and to remind you that this is part of a series. The next event is on the 22nd of July, and we'll deal with the Sustainable Farming Initiative, incentive. And then on the 27th of July, looking at natural capital and the economics of biodiversity. Both of those particularly interesting going forward, and things that have sparked a lot of interest from our members. So please join us. You can register for those events on the webpage as shown. And if you've got any further queries, contact us by email. But can I take this opportunity to thank everyone attending, but also to thank very much our panelists who have spoken and I hope provided some useful insight today. Thank you all very much.